me and my son were time in prison, and the guy that he beat up a 3-year-old child. My son is
speak with the victim. It's been very difficult for us to speak with him. I never was able to. I noticed in the PSI there is no victim impact statement, and I think part of the reason why there's difficulty is the victim actually is at the prison's medical center. That's where he's housed because of the injuries he received in this felonious assault. So there is no statement, but I don't want the court to be under the impression that's because this victim is not wanting to give a statement. I'm just not sure that there's been the ability to get that information.
Okay.
And probation could get a hold of him. I didn't know. I don't know that.
All right. Anything on behalf of the state?
Yes, Your Honor. I know, Judge, that you have a lot of felonious assault cases like this that come through this court from the 2 prisons we have here in Warren County. And I know you've expressed previously that a lot of what you look at when you determine a sentence in a case like this is the nature of the injury to the victim and the person that you're speaking of, the defendant's prior criminal history. And Judge, I can tell you that the victim was profoundly injured. He had fractures in the bones in his face. He had a brain bleed. He has permanent incapacities as a result of this. He has permanent damage to his motor skills, so he has difficulty walking as a result of this attack. So I would submit to the court, first of all, that the nature of this felonious assault and the injuries to the victim are such that Mr. White should be looking certainly at more than just a minimum sentence consecutive to his current term. And by current term, Judge, it's my understanding he is currently scheduled to be released on his prison term he's on now on July 23rd of this year. Then, Judge, if you take the injuries that the victim suffered and you add to that the defendant's very extensive criminal history with many, many offenses of violence in his past, I think that, again, you're talking about someone who should not be receiving a low-end sentence. He's currently in prison for aggravated burglary, and then some drug charges, and I know you have access to his record, but he is not someone unfamiliar with the prison system. And then, Judge, you add to that, if you look at the PSI and you look at the number of violations that have occurred while he's been in prison, it's page after page after page after page, including fights with other inmates, being essentially obstinate to the staff there. Mr. White is someone who is just a problem. And I think that when you have someone who clearly indicates to this court that he's not going to comply with the law if he's out of prison, he's not going to comply with the rules when he is in prison, and then he injures someone the way that he does, then I would submit to the court that's someone who deserves a sentence on the higher end of the range available. So from the state's perspective, Judge, we would ask for a sentence of at least 6 to 9 years in prison consecutive to his current term based on everything I've described.
All right, thank you.
So I think you take that into consideration, and we're asking for the minimum sentence, 2 to 3 year Greg and Tokes consecutive to his current sentence.
Okay, thank you. Mr. White, is there anything you'd like to say, sir?
Yes, Your Honor, there's actually a lot I'd like to say. First and foremost, I would like to withdraw my guilty plea. And then I would like to ask to dismiss my attorney for ineffective counsel because I requested a motion of discovery. I didn't receive the full discovery packet, which as in like the photos of the crime scene and all that, which I feel is important to see before, because as you told me, I shouldn't have to prove my innocence. They gotta prove my guilt. So right now, I feel like I gotta prove my innocence in this. And therefore, the reason I say that is because multiple times I've tried to get in contact with my attorney and have been unsuccessful. He's told my family that the way that we could communicate is through three-way calling, which is against institutional rules. And then what about attorney-client privilege? So on that, and then he stated that he's seen photos of the crime scene and all of the blood, which I was there was no blood at all. So that's I'm thinking that maybe he might have mine confused with somebody else. I just asked for like, I don't know. I don't feel comfortable. And then I'm being told I get 2 to 3 years, and then now I come here, and now that they're requesting that I get more. I just asked, can I get a 90-day grace period to try to come up with my family, to try to come up with a paid attorney?
And Your Honor, this is the first time hearing of it. I've not received any voicemails or any letters from him. I know I have, when I try to contact the prison and set up phone calls, they don't allow that anymore, and I've received a letter from the legal counsel of the prison that they don't allow that. So this is the first I'm hearing of it with Mr. White. And I can tell you also, the prosecutor and I did have discussions initially about a minimum consecutive sentence. Originally, he was going to talk to the victim before he made a formal offer. He had difficulty contacting the victim, and then eventually I believe the supervisor said they're not willing to make that offer, that we'd have to plead open to the court. So when he says he was told 2 to 3 years, that was initial plea negotiations, but there was no formal offer from the state. So this is the first I'm hearing that he wants new counsel.
Well, I'm not trying to get too technical here, but plea negotiations are really not relevant. And it's not admissible because the prosecutors could use them against the defense attorneys about 90% of the time, saying, well, he offered to plead guilty as long as he got X, Y, or Z. So plea negotiations I can't consider. I'm looking at the docket on the change of plea. We went over his constitutional rights. We went over all his rights, and not only do we have a recording of that, but I have his signature here along with the attorney's signature, and I understand you haven't heard this, and it's not that unusual if somebody at the last minute decides that they want to take a different approach. Generally, though, he entered a plea of guilty already. This is not whether or not he's guilty of the offense. He entered the plea. He did it knowingly and voluntarily. Anything from the state?
Judge, if you recall, we just had another hearing that began recently, bless you, on David Patrick, and I gave you a case in that case, or in that hearing, excuse me, regarding what's required of the court in making a determination like this. And we can certainly have a hearing right now on his motion, Judge. I have no problem with that. When you look at the factors that the court should consider and whether or not to withdraw a plea pre-sentencing, the main factors I would point out are, number one, a change of heart is not sufficient. Just saying, you know what, I changed my mind is not sufficient, especially when that is coupled with, and the case I gave to you mentions this, coupled with the idea that you're faced now with possibly a longer sentence than you expected.
Case of the State of Ohio versus Armand Dunlap, case number 26CR43449, present before the court.
District, and I just can't recall the name right now, but the case I gave in the 12th District, that was the issue. Also, Judge, the question is there the possibility that he has an absolute defense to the charge? And I would submit to the court, based on the evidence that the state has, and you've heard about this on more than one occasion in this case, that the state has sufficient evidence to prove him guilty. And I think probably the most telling aspect of what he just requested as to what his real motive in asking for this is, he said he wants a 90-day period of time just to get with his family and figure things out. And the least shocking thing that we've heard here today, he would be out of prison within those 90 days. So what he wants is, he wants to avoid the sentence he's about to get himself out of prison, and then who knows what would happen then. But I think that is the real motivation behind what he's asking for. Judge, as you mentioned, you gave him a proper rule of and colloquy. He indicated he understood all of his rights, he understood the maximum penalties, he understood what the charges were, and he acknowledged he was doing this knowingly of his own free will. And then today, he waits, and I can't recall the exact date, I can look, but I can't recall the exact date he entered his plea, but he waits a substantial period of time, Doesn't mention it when he has, he's doing the PSI. Doesn't mention it any other way. Doesn't file a motion with the court, any of that nature. He waits a substantial period of time to come in now and ask for to withdraw his plea, and the timeliness of the request is also another factor the court considers in whether to permit someone to withdraw their guilty plea. So I would submit to the court, based on the case law that this court's aware of and the factors that exist in determining whether or not a pre-sentencing motion to withdraw a plea should be granted, I think you should deny that request and proceed to sentencing.
It's 2 days shy of 6 weeks, yes. Mr. Oswald, you get the last word on this, if you like.
Your Honor, again, I just found out when he said that today, he's given me no indication he wanted to withdraw his plea prior to today. So, I mean, he can argue his own motion if he wants to do that.
Okay, well, I think he had that opportunity. Is there anything that you haven't said that you want to add, sir?
No, Your Honor.
To Mr. White.
I'm confused.
Well, I'll try and simplify it for you.
Okay.
You were charged, you were arraigned. There was 2 pretrials, I believe, in the case, if I'm not mistaken. And each time your attorney was here and discussed the case with you. And then on April 22nd, you entered a plea of guilty. I was here. I went through a series of your constitutional rights. I told you you had a right to a trial. I told you if you pled guilty, you would be giving up that right. I went through your right of confrontation. I went through the right to have witnesses ordered to appear and testify at your request. I went through the right against self-incrimination with you. I told you about post-release control. So I went over all the things that apply to the case other than telling you what the sentence was going to be. I didn't know what the sentence was going to be until I read the pre-sentence investigation. I've seen your record. I've seen the facts that were revealed in the pre-sentence investigation. I see nothing, which I've read, I see nothing that indicates there's any question whatsoever about what happened here. 2 men in a cell, one near dead, the way I understand it, and one's fine. One mentions to the guard that this man, something's wrong with him, and your statement was you don't know what happened to him. So we've addressed all this. You have a right to appeal the case, which I'll tell you about in a moment, but I'm overruling your motion at this time to appoint new counsel and withdraw your plea. All right, on sentencing. Based on the fact that this occurred while he was in prison, based on his lengthy criminal history, based upon his conduct while in prison, this basically leans more toward a maximum sentence in the case. He did accept responsibility on April 22nd, which I'll grant him some credit for. The sentence is 6 to 9 years in the case. 6 to 9 means 6 is the minimum number and 9 is the maximum number. It's rebuttably presumed that you will be released from service of the sentence.